Hello, everyone. This is Mark Wojcik, chair of the AALS section of International Law, welcoming you to our substantive program on the 75th anniversary of the United Nations. As you know, we were supposed to be meeting in San Francisco this week, the home of the United Nations, and 75 years ago, it was the birthplace of the United Nations. We're celebrating that today. We're examining its legacy, its future, its challenges, with a wonderful panel of speakers. I also want to point out that this Sunday, January 10th, will be the 75th anniversary of the first General Assembly meeting, which met in London. And so if you want to have a big party on Sunday for celebrating the 75th anniversary of the UN General Assembly, please send us all invites so that we can join you for that celebration as well. I'd like to thank PACE International Law Review and Professor Tom McDonald, who has made it possible for us to memorialize in a congressional record sort of way, where we can revise and extend our remarks because we know our time today is quite limited, that we can add more about each of the sections that we'll be talking about. We thank the students at PACE for taking this work on, and this is the second year that they've done that, so we're really grateful for them. Our first speaker is Hans Corell, Ambassador Hans Corell of Sweden, who was the Undersecretary General for Legal Affairs from 1994 to 2004. So we're in the Hamilton musical, In the Room Where It Happens. This is the guy who was in the room where it happened. He was making this happen for all of those years, and now he's in the Zoom where it happens. So we're happy for that. He was involved in the creation of the International Criminal Tribunal for Rwanda, for the Cambodia Tribunal, for the Special Court for Sierra Leone, for the International Tribunal for the Law of the Sea, and so many other things. And because it's more important to hear from him than to hear from me, Hans Corell, thank you for joining us from Sweden, and take it away.
Thank you very much for the invitation. It's a great pleasure to be with you here. And we have a very important topic to discuss, namely the United Nations at 75 and the challenges facing international law. But for me, it's impossible to start discussing this topic without addressing what happened in Washington, D.C. last Wednesday. This is the capital of one of the founding members of the United Nations, and also a permanent member of the Security Council. And what happened was so sad. What happened was so serious that I consider it actually a low water mark in the history of a country that I respect greatly, namely the United States of America. And the question that I ask myself now, if it is imperative to apply the 25th Amendment of the US Constitution. By way of introduction, the challenges to international law today, as I see it, are that democracy, human rights, and the rule of law are under attack. The lessons from the 2 world wars in the last century seem to be forgotten. My focus will be on the United Nations Security Council, which is the most powerful organ of the United Nations, but sometimes its weakest link. My observations are based on the fact that I was Secretary General for Legal Affairs and the Legal Council of the UN from 1994 to March 9, 2004, as you heard Mark say. Towards the end of that period, I met with Donald Trump. This was when he came to see Secretary General Kofi Annan to offer his services when we needed to repair the UN Secretariat building. Kofi Annan wanted me to be present when they met, and I never forget the manner in which Donald Trump behaved when the 3 of us were sitting in Kofi Annan's office that day. This is why I didn't believe my ears when I heard that he was a candidate in the 2016 presidential election, even less when I heard that he had been elected. In discussing the challenges, I will concentrate on the need for Security Council reform, since the Council has a key role to play here. My points of departure are that the focus of reform should not be on extending the membership of the Council, but on reform that could be executed almost immediately and without amendments to the UN Charter. That the reform should focus on the manner in which the members of the Security Council exercise their mandate and participate, and in particular, the responsibility that rests with the 5 permanent members. that the guiding principle for this reform should be respect for the rule of law at the national and international levels and the demands on the Council that such a regime entails. That the main responsibility rests with the permanent members of the Council, and that if they fail, there is a clear risk that the United Nations will lose authority and that the organization will be undermined. And finally, that the lodestar for the reform must be to safeguard the system of collective security in the UN Charter. In my presentation, I will focus on 10 elements for reducing the risk of conflicts in the world. The first element is the use of the veto. The permanent members should use their veto power only if their most serious and direct national interests are affected, and in case they do use the veto power, to explain the reasons for doing so. And here we have a very interesting development lately, namely a book by Professor Jennifer Trahan, who has written a book under the title Existing Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes. And I recommend that you look at that. I know that Layla Sadat has been involved also in presenting this book. But I think it's very important that this analysis she has made will be subject to an advisory opinion by the International Court of Justice. Let's hope that this happens. The second element is the need for the rule of law and human rights. And with respect to the rule of law, I often use a very straightforward and brief definition consisting of 4 elements, namely number 1, democracy, number 2, proper legislation respecting international human rights standards, number 3, the institutions to administer this law, including independent and impartial courts, and number 4, perhaps the most difficult one, the individuals with the integrity and the knowledge to administer these institutions. It should also be mentioned that one of the most serious challenges in implementing the rule of law is corruption. This is an extremely harmful factor which causes great damages to the efforts of establishing the rule of law. States have to act with determination here and live up to their obligations. Looking at the conflicts around the world and what causes them, a common denominator is that the root causes are basically the same: no democracy, no rule of law. A core ingredient in the rule of law is human rights. It's therefore necessary to strengthen the rule of law and protection of human rights. Both the UN General Assembly and the Security Council have made clear statements relating to the importance of the rule of law and human rights. The General Assembly has also stressed the need for democracy. The Assembly has reaffirmed that human rights, the rule of law, and democracy are interlinked and mutually reinforcing, and that they belong to the universal and indivisible core values and principles of the United Nations. The Security Council has referred to the General Assembly and has recognized the need for universal adherence and implementation of the rule of law, the vital importance it attaches to promoting justice and the rule of law, and as an indispensable element for peaceful coexistence and the prevention of conflict. Now, it is obvious that we should concentrate on how to improve the existing system with sovereign nation states interacting within the United Nations, where almost all of them, 193, are members. Members of the Security Council have an important role to play here through leading by example. A very serious problem is that the 5 permanent members often cannot agree where the need is the greatest. The latest serious instance is Syria. Another serious problem is that permanent members sometimes flagrantly violate the UN Charter. By way of example, can be mentioned the attack by the US and the United Kingdom on Iraq in 2003 with disastrous consequences, and then followed the attack by the Russian Federation on Georgia in 2008 and Ukraine in 2014. The third element I would like to focus on is the growth of the world population. When the United Nations was established in 1945, the world population was around 2 billion people. According to the United Nations Population Division, the world population prospects the 2019 revision. The current world population is 7.7 billion, and it is expected to reach almost 10 billion by 2050. By 2050. It's obvious that this enormous population growth will have extremely serious consequences for our human habitat. One serious effect will, of course, be rising CO2 emissions, unless science and the business can develop methods for counteracting this development. For the Security Council, the population growth may constitute a serious threat multiplier and needs to be observed with great attention by the members of the Council. The fourth element is climate change. As is commonly known, rising CO2 levels have caused climate change that simply has to be addressed. Reference should be made to the 1992 United Nations Framework Convention on Climate Change and the so-called Paris Agreement concluded in 2015. The central aim of the Paris Agreement is to strengthen the global response to the threat of climate change by keeping a global temperature rise this century well below 2 degrees Celsius, above pre-industrial levels, and to pursue efforts to limit the temperature increase even further to 1.5 degrees Celsius. There are presently 189 parties to this agreement, including 3 permanent members of the Security Council. Russian Federation is not a member, and unfortunately the United States of America withdrew from this agreement on the 4th of November 2020. Let us hope that President Biden will bring the US back to this agreement. A common effort simply has to be made to cope with the results of the climate change. There is a clear connection with international peace and security here. It may be that at the turn of the next century, there could be a 1-meter sea level rise. This would have disastrous effects on the globe and create millions of refugees. To this will be added the risk for further desertification in parts of the world, which will generate additional climate refugees. The impact of climate change on peace and security in Africa is increasing, particularly in the Lake Chad Basin, the Sahel region, and the Horn of Africa region. It is therefore important that the Security Council intensifies its focus on climate change as a threat multiplier. The fifth element is responsibility to protect. The concept here of responsibility to protect was introduced in the UN system in September 2005, when the General Assembly, based on the proposal by the high-level panel of threats, challenges and change, adopted the World Summit outcome. In this resolution, we find the 2 famous paragraphs 138 and 139. I also would like to mention the work of Kofi Annan in Kenya 2008 to 2013 and in Syria 2011-2012. This is a question of responsibility to protect. The African Union had asked him to chair the panel of eminent African personality to deal with the situation in Kenya after the disastrous presidential election in December 2007. And here he managed to have the parties sit down, conclude an agreement, and form a grand coalition government based on legislation that we elaborated as a draft for them. And this legislation governed a grand coalition government in the country for 5 years. When he got his mission in Syria, we were sitting here, actually in my apartment here in Stockholm, discussing in April 2012 whether he could work in Syria as he had worked in Kenya. After a while, he fell silent and said, "No, Hans, I can't, because I do not have the support of the Security Council, which is a precondition for succeeding here. I'm going to leave this mission," which he did in August 2012. Also, the role of the international criminal justice system should be pointed at here, but Professor Sadat will present this topic where the Security Council has a role under Article 13b of the Rome Statute for the ICC. If, namely, the officials who bear the greatest responsibility for international crimes committed in a particular situation are not brought to justice, this constitutes a clear risk, not only for a continuation of the conflict at hand, but also for breeding new conflicts in the future. I also would come now to the sixth element, namely empowerment of women. The importance of empowerment of women cannot be stressed enough. It is one of the most central issues for the future. Looking at the Convention on the Elimination of All Forms of Discrimination Against Women from 1979, it has now 189 parties. Compare with the UN membership, currently 193 member states. It's telling. The two main purposes of the very important Security Council Resolution 1325/2000 is to protect women and children affected by armed conflict and to ensure increased representation of women at all decision-making levels in national, regional and international institutions and mechanisms for the prevention, management and resolution of conflict. The present efforts to empower and protect women must continue with determination, since this is of great importance when the Council is exercising the mandate conferred to it under Article 24 of the Charter, the primary responsibility for the maintenance of international peace and security. The seventh element is nuclear disarmament. This is a very serious matter for the simple reason that there is a lack of process in nuclear disarmament. It is true that we now have the 2017 Treaty on the Prohibition of Nuclear Weapons. This is important. However, at present, the Treaty on the Non-Proliferation of Nuclear Weapons, the NPT of 1968, is still the cornerstone in this effort in the nuclear disarmament and non-proliferation regime. The NPT has a vital role to play in promoting international peace and security, and so has the Comprehensive Nuclear Test Ban Treaty and its verification regime. The NPT recognizes 5 nuclear states, namely France, China, the Russian Federation, the United Kingdom, and the US. In other words, the 5 permanent members of the Security Council. But as we know, there are also other states that possess nuclear arms. I refer to India, Israel, Pakistan, and now also North Korea. In light of the situation related to the global coronavirus, the COVID-19 pandemic, states parties to the NPT have decided to postpone the 10th review conference of the parties to the treaty to a date no later than August 2021. It is extremely important that this process can be led in a positive direction after the setbacks during the last years. As is well known, on the 8th of July 1996, the International Court of Justice delivered an advisory opinion on the legality of the threat or use of nuclear weapons. In view of what we now know about the effects of the use of nuclear weapons, the question is if the General Assembly should request a second opinion from the International Court of Justice. Is it possible to use nuclear arms at all without violating international humanitarian law? What is required now is that the nuclear weapon states, the 5 permanent members of the Security Council, confirm their obligations under the NPT and make serious their obligations to work for a nuclear weapon-free world. It is obvious that all states that possess nuclear weapons must participate here. I would also like to refer to the so-called Joint Comprehensive Plan of Action, the JCPOA. That's a problem also related to the Security Council. It's the fact that the United States left the JCPOA. This is very serious. It was concluded on the 14th of July 2015. Let us hope that President Biden can bring the US back into this agreement. I actually wonder whether the US withdrawal from the JCPOA was legal after the endorsement of the agreement by the Security Council. Because when the Council endorsed the agreement, they also ordered all states to observe the JCPOA. This applies also to the United States of America. The eighth element here is cooperation between the Security Council and regional organizations. This kind of cooperation is a matter that is given great attention within the UN. The focus is on cooperation between the UN and regional and sub-regional organizations in the prevention and resolution of conflicts. These organizations have an important role to play in conformity with Chapter 8 of the UN Charter. Particular attention has been paid to Africa. There's an obvious need for partnership in conflict prevention and peacemaking. An important ingredient here is the need for the rule of law and protection of human rights. And another precondition is observance of international humanitarian law. Now, I would like to make some general observations here towards the end. First of all, it is obvious that an effective Security Council is a precondition for establishing international peace and security in the future. Of particular importance is that the permanent members of the Council bow to the law here. Security Council reform is necessary. At the same time, it is fundamental to preserve the Security Council as an executive organ. Too many members would destroy this requirement completely, in particular if additional members are granted veto power. In the debate, there are frequent suggestions that new members should be added to the Council. The figure 11 has been indicated by several states. If so many members are added, there is a clear risk that the Council becomes inoperable. At that, it will not solve the real problem with the Council, namely the manner in which the permanent members sometimes behave. The permanent 5 members simply must engage in a profound discussion about their performance and the manner in which the veto power is exercised. Another requirement is that they can agree on how to set the example with respect to the rule of law and human rights. And here I would like to make a reference to an article that I wrote a little more than a year ago, which was published and it's available on my website. It's entitled UN Security Council Reform. The Council must lead by example. So just Google my name and you will find this publication. I also submitted it to the ALCC LSS so that it's available on the website there. I think this is so important. And when I focus so much on the Security Council, when we are discussing respect for international law in general, it is because, as I said at the outset, the Council has an extremely important role to play here. Because if the Council doesn't lead by example, how can we expect that others will, shall we say, respect the international law? So the members of the United Nations must make a joint effort, including in particular through responsible, credible and even-handed action by the Security Council to make certain that the system created by the Charter of the United Nations for the maintenance of international peace and security, including assuring human rights for all human beings, can be effectively upheld. Finally, I came to the 2 remaining elements here. The 9th element is Sustainable Development Goal 16. Looking at the 17 Sustainable Development Goals, there is one thing that must be understood. In order to achieve all these goals, one of them must be attained, namely Goal 16, quote, promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels, unquote. Among the targets of this goal are promote the rule of law at the national and international levels and substantially reduce corruption and bribery in all its forms. These are absolutely crucial elements for creating the legal order that is a precondition, a prerequisite for achieving all the other goals. And then finally, the 10th element, the need for education about human rights and the rule of law, which of course is a matter on the agenda of the law schools organizing this conference. What all this boils down to is that people must gain knowledge and insight about what needs to be done and find the political will and the necessary techniques to achieve this. In this context, it is absolutely necessary to see to it that education about human rights and the rule of law is given in schools as early as possible. Politicians and the general public must also be educated. Let me finish by referring to a meeting of the Interaction Council of former heads of state and government in 2008. In this meeting, former Chancellor Helmut Schmidt of Germany, who was 90 years at the time, made a comment. I wonder if politicians understand their responsibility for the rule of law. That comment inspired the elaboration of a short guide for politicians on the rule of law. This guide is now available free of charge for downloading and printing from the web in 26 languages, with more to come. So I have also made a reference in the material I submitted to the ALSS to this guide, but otherwise you just Google rule of law, a guide for politicians, and you will find it immediately. And I hope that this will be used also by law schools in the sense that it's written for laymen and it's not too complex, but it could be spread, the knowledge about the guide, so it could be used for educating the politicians. Because if they don't understand their responsibility for the rule of law, we are in a very difficult situation. With this, I thank you for your attention, and I look forward to the further discussions and your contributions. Thank you very much.
So thank you to Ambassador Correll for these really insightful remarks. We're next going to turn to Professor Ved Nanda for remarks. And I should just introduce myself briefly. I am co-moderating this session, and I'm Hari Osofsky, Dean of Penn State Law and the Penn State School of International Affairs. And I also, before turning to our next speaker, Ved Nanda, just wanted us all to take a moment to thank Professor Wojcik for his incredible leadership of this section over this past year. I'm sure when he signed up for it, he did not anticipate doing it during a global pandemic. And he's really done a wonderful job, not just organizing this session, but in his leadership of the section. So a big, big thank you.
Thank you, Hari, for that acknowledgement. I also wanted to invite people who are watching this session on chat just to introduce yourselves. Just type in your name and what school you're at so that we know that you're there. Thanks.
Wonderful. And I will, at the end, as we have time for questions, be making sure, bringing to the panelists any of the questions you're putting into chat. So please feel free to put questions or comments there. So as I said, we're building, it's such a richness of speakers in this session. So after Ambassador Correll, we now have Professor Ved Nanda speaking from the University of Denver Stern College of Law. He's a distinguished university professor. He's He's director of the Vednanda Center for International and Comparative Law and the founding director and director emeritus of the International Studies Program at the University of Denver Sturm College of Law. So thank you very much, and we will turn next to you for your insights.
Well, thank you very much, Dean Osofsky. And in his usual masterful fashion, Ambassador Corral has given us sage and very special advice to us. It's talking about the Security Council, which really is paralyzed and has not been able to function, and he has asked for its reform. And obviously all of us totally agree with it, although Ambassador Corral did mention, and that is appropriate to say, that today, with the world having changed, many countries don't feel that the present structure of the Security Council meets the needs of the international community. And the 5 permanent members are there, but the rest of the members, I think, do not reflect at the present time the changing face of international community. And the point simply is that Asia, Latin America, Africa, where is the representation? How representative is the Security Council? Where does Britain and France at the present time, where do they fit in the Security Council? I wouldn't go further into it, but obviously the need in order to reform the Security Council is obvious. I begin by recalling the last year's President of the General Assembly, who said, and I quote, "In current times, we need a strong, predictable, reliable international law order in order to deliver on the 3 pillars of the UN Charter: peace and security, human rights and development, which has been translated into a very powerful contemporary social contract, the 2030 Agenda, and the Sustainable Development Goals." And then the Secretary General, I think he appropriately said, he said, "Today we have a surplus of multilateral challenges and a deficit of multilateral solutions." And addressing the Assembly, he said, "COVID-19 has laid before the world's fragilities, laid bare the world's fragilities." He said, "Climate calamity looms, biodiversity is collapsing, poverty is rising, hatred is spreading, geopolitical tensions are escalating, nuclear weapons remain on hair trigger alert." And so there is no dearth of challenges that the world community at the present time faces, and that the United Nations faces, and international law faces at the present time. Like many of my colleagues today who are on the panel, I teach international law, have done that for the last 5 decades. Early on in my course, I discussed challenges to international law and the United Nations, especially talk about the United Nations contribution in developing international law commission, 6th Committee of the General Assembly, and the International Court of Justice. This year, as I began, we discussed the crises the world community faces, including the frightening COVID pandemic, the climate crisis, geopolitical tensions, global polarization, armed conflict, growing inequality within among nations, genocide, terrorism, human rights violations, environmental degradation. There is no dearth of them. And this year again was no exception. During the first week, or perhaps the second week, one student remarked about the image of the United Nations, that all we hear is about the veto. And when I spoke about the 75th anniversary of the UN, again, the Security Council being paralyzed, became an important issue. Another one, that WHO has been incapable of providing global health governance. Because I talk about norms, I talk about institutions, I talk about processes. And that is where these issues came up. The lack of adequate enforcement mechanisms, lack of confidence in our institutions, atmosphere of alienation, cynicism, and often mentioned by my students among all those challenges, especially for international law. And as I said, as I focus on international law norms, institutions, processes, as the foundation of what continues to be the international legal framework in the post-World War era. And this is the bedrock on which multilateralism was founded and maintained, and which in turn is the foundation for the United Nations work. I mentioned briefly, the world has changed dramatically in the last 75 years. New states have emerged, their own needs, their own priorities, their own preferences. West no longer has the control and power over regulating all international events and activities. Populism, nationalism, and protectionism have taken root in many countries. And so the challenge is not only to the international rule of law, but even the rule of law is under siege in many countries. Obviously, in the last 75 years, the United Nations has done wonderful work. You have treaties, you've got decolonization, human rights standards have been set. Treaties have talked about not simply equal protection, but no discrimination. Apartheid ended, eradication of diseases, reduction in hunger, and development of international law, and all these treaties to protect the environment. And as we look toward the future, and as I talked about it, not simply the international rule of law is under siege, not only is multilateralism under siege, with unilateralism in many parts of the world, and even in the Western countries today. I won't name many countries, but I take my own country, the United States. Ambassador Correll talked about Mr. Trump as he came into power and began with the slogan, America First, which simply meant America alone. He flouted both norms and institutions of international law and multilateralism. And as I think about him and think about his own contribution, and not only did he talk about NATO being defunct and NATO being obsolete, but then he's the one who threw away, withdrawing from so many international agreements and organizations and threatening to withdraw from others. Not only the Iran nuclear deal, Paris Accord, WHO, UNESCO, the Open Skies Agreement, the Intermediate Range Nuclear Forces Treaty with Russia, Human Rights Council, compacts on migration and refugees, Trans-Pacific Partnership, and many more. And he has conducted transactional rather than strategic foreign policy. And the point simply that I'm making is that challenge at that present time is to multilateralism. Challenge at the present time, 75th anniversary, is at the present time to the rule of law. And it's not simply international rule of law, but rule of law in our own countries. And what is the answer? Because as you think about UN providing the framework of international law, norms, mechanisms, and from the foundation and its own and promotion of human rights, regulation of nuclear, chemical, biological weapons, taking care of global commons, international peace and security. And the problem at the present time is that the harsh reality of world politics, which lies at the foundation of international law. International law does not function in a vacuum. It is within the human, within the world politics that it operates. And so at the present time, the answer that I can see, and I'll conclude by saying that, answer that I'm seeing is reinvigorated multilateralism, but not the multilateralism whose policies are being set by the West. But international law at the present time, challenge before it is how, and challenge before the world community is how that multilateralism functions, and international law is how it can respond to all these challenges at the present time, which obviously are totally woven in the fabric of politics. And so political setting, political relations, national relations, and international law, they've got to converge. And international law obviously is going to be at the present time where sometime people feel it's irrelevant. I do consider very strongly, along with others, that it is at the present time absolutely essential in order to provide some kind of rules of the game and international rules of law as the foundation of international legal framework is absolutely essential for us to strengthen and reinvigorate. Thank you very much.
Thank you so much, Professor Nanda, for these really interesting and thoughtful remarks. Our next speaker is Professor Leila Sadat of the Washington University in St. Louis School of Law. She's the James Carr Professor of International Law, Director of the Whitney R. Harris World Law Institute, and Special Advisor on Crimes Against Humanity to the ICC Prosecutor. Professor Sadat, we look forward to your insights.
Thank you so much. Can everybody hear me all right? I know that this is a slightly awkward platform. It's wonderful to be here, and I want to thank Mark and Hari for really organizing this section and carrying the session forward. It's been a really tough year for all of us. So and 2021 is sort of starting off with an explosion. So let's hope it gets calmer, more peaceful, and it's a little bit of a smoother ride from here on out. I'm going to speak in just my few minutes. I'm going to pick up where our two, in a way, principal speakers, Ambassador Currell and Professor Nanda, have left off, and pick up from something that Ambassador Currell said, which is, are the lessons of the past being forgotten? So my assignment for this panel was to talk about the UN International Criminal Tribunals, as well as the search for international justice that really started in the 1990s. But of course, we have to go back to Nuremberg to think about the impetus for that movement. And at Nuremberg, we know that the Allied powers, so enraged were they by the atrocities in the war, even if slightly hypocritically with respect to certain aspects of that, decided to try the Germans and subsequently Japanese leaders for war crimes, crimes against humanity, and crimes against peace. And an international military tribunal was set up. It was established by treaty. Ultimately, 23 states joined that treaty. And the judgment in that case said that aggression or war making is the supreme international crime. Now, one of the things that happened in the 1990s is that when the decision was made to create the ad hoc international criminal tribunals by the United Nations, which was a miracle in and of itself, made possible only by the efforts of individuals like Ambassador Currell, who was very involved in the negotiation of the ICTY and ICTR statute, as well as the end of the Cold War, which made progress on some of the Nuremberg agendas possible. But when those tribunals were established, one will note that aggression was left out. crimes against peace were not part of those tribunals. Now, with the Rwanda Tribunal, of course, that is a completely logical perspective. But there was an argument that the waging of the war itself, not just the atrocities committed in the war in the former Yugoslavia, was criminal. And that was pushed to the side largely because we made a shift, as Samuel Moyn recently argued in an essay that I found very, very interesting. We've made a shift from aggression as the supreme crime to atrocity. And the idea is if we can just humanize war, then we can, and criminalize the worst aspects of it, maybe that's the best we can do. And what's interesting is if we go back to the past and we look at the great powers, a new book on this called The Soviet Nuremberg, which I recommend to everybody, shows that the Soviets, just like the Americans, were very, very keen on the crimes against peace charges. They pushed very, very hard for them. They thought that was the key aspect of the war. So I don't want to take anything away from what needs to be a true celebration of the miracle of achievement of having a United Nations that has endured for 75 years, much longer, obviously, than the League of Nations. But I do want to encourage, building on what Professor Nanda said and what Ambassador Corral said, that the purpose of the organization was to prevent war. It was to prevent war, which had twice in the lifetime of those negotiating the charter in San Francisco and ratifying it been a scourge and brought untold sorrow to humankind. And I do think as we enter this new year, this 21st the 2021, we have to think about the fact that the International Criminal Court, which is in a way not a United Nations organ stricto sensu, but brought into relationship with the United Nations. We've just seen the introduction of the crime of aggression into the ICC charter with huge pushback from the very states that, of course, wanted to establish the United Nations as an institution that would prevent war in our lifetime. And so while I applaud, and as people know, I actually work with the ICC prosecutor, who alas is under American sanctions right now. So my work has been postponed temporarily. But I do think that we have work to do. There's a wonderful quote, and Ambassador Corral, you'll tell me if I'm misquoting it, but Ban Ki-moon said at the United Nations, we don't believe in miracles, we believe in hard work, but sometimes small miracles occur. And I do think the establishment of the ad hoc tribunals, the establishment of the justice mechanisms we have, those were the kind of small miracles that could only take place because of the dedicated efforts of so many individuals working so hard, first to staunch and humanize the atrocities of war. But now we really have to take on the harder questions, which is prevention of nuclear proliferation, climate change, and all those things that can lead to aggression and lead to war. So I think I'll stop there. I was given 5 minutes, and I want to leave lots and lots of time for questions and answers. But thank you for allowing me to participate and to be here with friends and colleagues to talk about these really important issues.
Thank you, Professor Sadat. And I think we need both some small miracles, maybe even bigger ones, and some hard work right now. I next have the great pleasure of introducing our next speaker, Professor George Edwards from the Indiana University Robert H. McKinney School of Law. He is the Carl M. Gray Professor of Law, Director of the Program in International Human Rights Law, and John S. Grimes Fellow. And we very much look forward to your insights, Professor Edwards.
Thank you very much. We've heard a bit about the UN from the official side, about various aspects of how the different organs of the UN work. We've heard from officials about officials on the official side. I'm going to talk today a little bit about kind of the other side, or a different side of the NGO, the side that perhaps relates to many of us who are academics. We are involved with non-governmental organizations. We approach the UN from a different perspective. So my topic today is non-governmental organizations, the relationship between them and the United Nations over the last 75 years. there's an awful lot of ground to cover. I will do the best as I can in just a couple of moments. I'll talk about the proliferation of non-governmental organizations, the legal bases for the relationship between UN and NGOs, different types of relations that exist between the two, how to get accredited to the United Nations as an NGO, even if you're part of an academic institution, the benefits of that, and then the future. So I'm not going to talk a lot about what is an NGO. The term is quite elusive, and it's defined in part by what it's not rather than what it is, hence the word non-governmental. There are 2 articles that address that topic in the context of the UN. Well, there are many articles, but 2 that come to mind are one written by Professor Nanda, who's on our panel, of course, that was published just after the 50th anniversary of the UN, so back in 1997. And then I published an article 10 years later after the 60th anniversary. His was titled The Human Rights Era of 50 Years, the Human Rights Era within the UN System After 50 Years, and mine was Assessing the Effectiveness of Human Rights NGOs from the Birth of the UN to the 21st Century. Mine's Michigan State Journal of International Law. His was in the Willamette Journal of International Law. But on proliferation, I can say that in 1945, there were 41 different NGOs that were granted consultative status at San Francisco, and those groups contributed greatly to the negotiation of the UN Charter. We jumped forward 50 years to the early 1990s, and we had 700 NGOs that had this status. In 2020, the last figure I have from April of this past year was 5,441. So 41 and 45, 700 in 1992, 5,400 in April of 2020. And these NGOs are quite a very powerful resource for the UN and for the people that these NGOs serve out in the community. So what are the legal bases for these relationships? Well, built into the Charter, Article 71 is the first reference to the term non-governmental organizations, and the first reference within the UN system. And it provides that the ECOSOC, the Economic and Social Council, that's precatory, not mandatory, may make suitable arrangements for consultation with non-governmental organizations. And so there you have it. Coupled with this second phrase, which is that such arrangements may, again, precatory, not mandatory, may be made with international organizations. So international NGOs were preferred over national organizations, which came in the clause immediately following that. But there you have the creation of this official relationship between NGOs and the UN. ECOSOC picked up on that Article 71, and in 1950, it generated the first resolution that specifically regulated this relationship. In 1968, there was an update, and then there was an update in 1996. 1996/31 is the resolution number, and that is the resolution that governs the relationship today. It provides for rules for eligibility of NGOs to acquire consultative status, NGOs' rights and obligations, the roles and functions of the NGO committee that gives its stamp of approval to NGOs, and responsibilities of the UN Secretariat regarding fulfilling the promise of the UN vis-a-vis these NGOs. So that's on the treaty side. But what about on the customary international law side? Is there a customary international law obligation on the UN and other intergovernmental organizations to consult with NGOs? Well, we have ample state practice that goes back 75 years, but the opinio juris side, it's up for debate. We have some scholars that argue yes and some that argue no. Beyond the scope of this presentation, just wanted to give you some food for thought. But NGOs with consultative status fall into 3 different categories. We have a general status, we have special consultative status, and roster status. At the moment, there are about 140 NGOs that have general status. They tend to be broad international groups. And then we have special consultative status. There are about 4,000 of those, and they have more focused abilities and competence to work within the UN system. And I think most of the human rights groups that many of us are familiar with do have that second category, special consultative status, including the Program in International Human Rights Law that I founded at Indiana McKinney School of Law, Indiana University McKinney School of Law back in 1997, we began the process for application for the status in about 2006, 2007, and were granted it in 2011. I'll talk a bit about that in just a moment. And then the third category is the roster category, and there are about 1,000 of those groups. So a total of 5,451, most in the special consultative status group. How to get accreditation, as we did get for our program in international human rights law? Well, it takes determination, it takes persistence, it takes creativity, and it takes a lot of patience. As I mentioned, it took us almost 5 years to acquire the status. The hurdles are somewhat high. They were high then, they're high now. And very briefly, then I'll wrap up, is that it calls upon the group, however, whether they call themselves an NGO or not, they need to be an NGO in order to get this status. But they have to be in existence for 2 years. Now, that's easy enough, but they have to be able to prove it with a document that was issued by a due government, so duly issued by a governmental authority, that this group is an NGO and that it has been in existence for 2 years. Maybe if you are kind of a traditional NGO, sure, and that if you have kind of the imprimatur of some state, but if you are, and like my school, my program is an academic program at a law faculty that's part of a campus and that is part of an overall university that happens to be public, kind of an extension of the government, which is another set of issues. But that you need, and then you need to have an established headquarters, a democratically adopted constitution, transparent and democratic decision-making processes, and authority to speak on behalf of members, and you have to have funding that's not questionable, and then you have to submit financial statements. But the benefits are great to the UN. They get the benefit of the expertise of the NGOs that contribute. And of course, the NGOs benefit quite a bit as well. We're better able to do our jobs if we have kind of the stamp of approval of the UN. We can attend conferences, access the human rights mechanisms, the General Assembly meetings. We can join debates. We can speak on the floor with written statements to also disseminate it to groups. We get these fancy UN badges that we get to wear around our necks and that grant us access to the premises in Geneva, New York, and Bangkok, and other facilities around the globe. And we get to eat at the UN cafeteria. And for some people, a great perk is that you get a 10% discount at the UN bookstore and gift shop. So I'll conclude by saying NGOs are here to stay within the UN system, especially human rights NGOs, because there are many categories. And it's a win-win. The UN wins, the NGOs win, and human rights win. So thank you.
Thank you for sharing these wonderful insights into how NGOs fit into this picture. Our last speaker, but certainly not our least, is Professor Mark Wojcik from the UIC John Marshall School of Law. After his remarks, we'll do some Q&A, and then we are briefly at the end of this session going to hold the section's election. So with that, I will turn it over to Professor Wojcik.
Thank you, Harry, our incoming chair of the section on international law, and what a great panel. If you've ever wondered if you should be on a double ALS section, the answer is yes, because you get to be involved in programs like this with these amazing fellow panelists. For those of you who joined late, I just wanted to remind you that this coming Sunday, January 10th, is the 75th anniversary of the first General Assembly meeting in London. So if you're going to have if you're looking for parties to plan this weekend, please plan a UN General Assembly 75th anniversary party. I'm going to speak very briefly about the UN Trusteeship Council, one of the 6 permanent organs of the United Nations. I will leave most of my remarks for the article that we're doing in the PACE International Law Review. And I just want to invite any of the speakers who are knowledgeable about other areas that we haven't talked about. If you want to contact the PACE International Law Review and add in an additional article for this session, I'm sure they would welcome your participation. The Trusteeship Council had as its mission the supervising of trustee territories for the benefit of the inhabitants and for the maintenance of international peace and security. The Trusteeship Council shut down its work in 1994 after the Republic of Palau which was the last strategic trust territory of the United Nations administered by the United States, finished its work. I was court counsel for the Supreme Court of Palau when that happened. I have a picture. I'll just share it with you here. This is me in 1994, sitting, doing my international law work in front of a traditional bai of Palau, one of the men's meeting houses. And I spent the first year of Palau was with me as one of the court counsel at the Supreme Court. The Palau had been previously a mandate to the League of Nations administered by Japan, and became then the last trust territory of the United Nations. When Palau became an independent country on October 1st, 1994, that the Trusteeship Council ceased its work. It didn't shut down, but it's just took a pause on everything left to do. And it's one of the silent success stories, I think, about the United Nations, is that much of the work of the United Nations is talking about, well, you can't control this, you can't control this, but so much happens that we never know about. And I think the Trusteeship Council is one of those success stories in many ways. It's not a perfect story, but it has many successful attributes to it. I also wanted to say a quick word about specialized agencies of the United Nations. The World Health Organization, of course, has seen now two pandemics in recent times. AIDS, which created also the UN AIDS organization. UN AIDS as a way of dealing with the pandemic, and now with the COVID. We have a vaccine. We have several vaccines now. We can see the light at the end of the tunnel, but we're still in the tunnel. And we know that like AIDS, COVID is not going to be cured in any country until it's cured in all countries. And we need to work together. We need the United Nations. We need the World Health Organization. We need to support that, to be part of that, to be members of that World Health Organization, to help be sure that this is cured in all countries. Thank you, everyone. We invite your questions now. If please, populate the chat with whatever comments and questions you have for any of the speakers. If we don't get to it during these next few minutes, we'll try and contact you individually as well.
Great. Well, thank you for those really thoughtful remarks. And so the one question or comment I see in the chat besides the introductions is from Lynn Harmon Walker saying that Professor Nanda, wish we had more time to discuss multilateralism, especially with a huge part of the US population disdainful of the international community. And so I just wanted to open it up to Professor Nanda and any other panelists who wants to comment on sort of further thoughts on multilateralism issues.
That seems to be frozen in his video, but we also want to congratulate him on receiving the Founders Award from his university. He's the first faculty member, I think, in 160 years to receive that award. So congratulations to you, Ved.
So I join you in congratulating, and I don't know if you heard the question while you were frozen, Professor Nanda.
No, I didn't.
Okay, so the question was about multilateralism, and in particular, kind of if you had further thoughts on multilateralism in the context in which a huge part of the U.S. population is disdainful of the international community.
I do, and what I will do is I'm writing an article on it, and I'll give all the citations. But multilateralism, as you probably know, is the issue that at the 75th anniversary, the United Nations General Assembly had many speakers talk about it. And I think multilateralism became the hub of this year's General Assembly program, but I'll send all the information. And I'll send the information to the person also, because right now I don't want to monopolize the time. I do have citations right here.
Thank you very much, Professor Nanda. I'm not seeing additional questions, so perhaps I'll ask a follow. Oh, here we go. Never mind. I do have a follow-up that you might get to hear if we have enough time. You might imagine I have some thoughts about climate change right now, but this also is on climate change. So Craig Martin says, I have a question that flows from Ambassador Correll's comments about the UN Security Council focus on climate change, and to ask whether he can envision a time when the UN Security Council might identify the greenhouse gas emissions of certain outlier countries as posing a threat to international peace and security, and potentially even authorize collective action to address such threats. So Ambassador, I don't know if you have thoughts on that question.
I'm not sure that I understood all the details about it, but what I would like to say is that climate change is a major issue, and obviously the Council cannot solve this, but what the Council, by its own, the Council can actually encourage states to take initiatives and also see to it that they themselves fulfill their obligations that they have. And in particular, I would say that the last few years, the attitude that we've seen from the US is rather unproductive. And at the same time, I know that there are so many scientists in your countries that are contributing to the work here. So what we have to expect from the Council is that to support this work and to remind states that they have to continue working here to try to avoid the conflict, shall we say, effects of the climate change that the Council otherwise has to deal with. Thank you.
Thank you. I see a question that's directed at Ambassador Correll and Professor Nanda, though I'm sure others have views on it too, which is how do we stop the rise of ultra-nationalist leaders and illiberal democracies? And of course, I'll
repeat the question. It's difficult to hear in Sweden here. You have to be very clear when you read out the questions. Thank you.
All right, I will read it more slowly and clearly, or will at least aim to. I've been having connectivity problems too, so if I'm too unclear, just let me know. But the question is, how do we stop the rise of ultra-nationalist leaders and illiberal democracies? A question that seems particularly appropriate this week in our country.
Well, if it was directed to me, I mean, this is one of the problems. And when I'm speaking about democracy, I am always, when I have more time, stressing the fact that democracy is not a guarantee that the person elected as a leader will be a statesman or a stateswoman. And this is one of the problems with the democracy. And this is also why it's so important that people participate in the national discussions, and in particular from academia, where we warn the general public from running into populist arguments here, and that they have to really look to the future and to see that what we need is statesmanship, statesmen and women who can look to the horizon and who understand that their responsibility is not only to their own country, it is to the humanity. And it is not to the present generation only, it is also for coming generations. Thank you.
I think I would probably add to it that at the present time, what we all consider to be obvious, and that is that from the very beginning, the child has got to start learning about human rights. The child has got to start learning about the rule of law. And that is where it all begins. And those formative years from there to a person who has then graduated from school or college and has gone into careers, I think point simply is that you've got to change the culture in order to make bring about that change. I was just thinking about it that day before yesterday, 2 days before, when all this riot happened and mob came in and all that constitutional mandate was being thrown away. At that time, the woman who was killed, Ashley Babbitt,
I think we're losing Bed's connection here.
Yes, it's always, of course, hard to tell whether it's Ved's connection or mine. I know this is the joys of panels in the world of Zoom. Is he back now?
Red is back now, yes.
All right. I can I'll conclude it by saying that she's the one who said, talking about it, 1776. And so it was an insurrection. And I think the point simply is that you are absolutely right. These populist leaders, nationalists, extreme nationalists, and they are the challenge to democracy. And democracy deficit is known to many, but in order to improve that, this is not the answer. One of those people said, we wanted to show these politicians, it's us who is in charge, not them. Well, that's the challenge to democracy. We got the strength, he said. And then he shouted, we're the ones who are going to set the rules, not these people. And the effort, as you know, at that time was that certification, that process has got to be derailed. So I think education, creating that culture, those are the answers in order to have see that these demagogues don't come to power.
So we have a comment in the chat about educating our students, and that actually strikes me as probably a good place to start to wind up this panel, with apologies to not making it to every single question in the chat. And I know Professor Sadat indicated that she might be able to provide some insights into, I think this very critical, the comment really leads to a very critical question, which is, it's certainly been in my mind watching the events in our country in the past week, sort of how do we engage both in the education we're doing in the law school setting, but more broadly in civic education around these issues. And so I'll turn that to Professor Sadat first.
Thank you so much. And so much could be said about that. When teaching international law in a U.S. law school, one is very much challenged, I think, to not focus too heavily on U.S. foreign relations law and what is the practice of the U.S. government in a particular case. And so one of the things that I do in my class is students represent a country for a semester. And so when I teach the Genocide Convention, I say, has your state ratified? Does it have any reservations, any declarations? And students find that very, very interesting. Some of them really enjoy the exercise. They actually take on the persona of the government. Others don't, but it makes for a very interesting kind of diverse conversation. Of course, we do the foreign relations cases, and for that class, they're not asked to do that. We also do a UN simulation, in which they represent their country. And this year, we argued about the 2017 nuclear treaty, the treaty to ban nuclear weapons. And so they learned from that Latin America was a nuclear-free zone, and they learned that things are different. Zoom actually offers us a really fun opportunity. I use screens, I use videos, I change my backgrounds, I do lots of really fun things to take them around the world virtually. I don't know how that's going to happen when I return back to the classroom, because it's easy for me to do it at home and maybe less difficult. But I think education is critically important. And I do think our students are younger. I live with 2 teenagers, and they need to be stimulated and introduced to things in a way that maybe it's a little bit non-traditional. One of the other things, I'll just conclude with this, Hari, and it goes again back to the very first thing Ambassador Correll said, which is we have forgotten the past. We have not learned the lessons of the past. If you think about Brexit and what the British just endured with a populist movement that drove them out of the European Union, and any of you who are watching The Crown will remember all the episodes when England is having blackouts and there's not enough electricity and they're poor and nothing is going well with their economy, and entry into the European Economic Community is actually what brings prosperity back to the UK in a large measure. And I think we have forgotten a lot of those lessons, and reteaching that to our students, I think, is critically important. And we have more tools than ever to do it. So that's the hopeful side of it, right? Is that technology allows illiberalism to fester, but it also allows us as educators to reach deeper into even the emotional psyche of students who are looking for pathways and answers. So I'll stop there.
Thank you, Professor Sadat. Professor Edwards, did you want to add on there too? I saw you nodding at one point.
No. I'm fine. I'll leave it with Professor Sadat.
All right. Well, then, if people who are in the chat could please stay on, because we do need you to vote in this election we're about to do. Speaking of liberalism. But I just want us all to first virtually thank these amazing panelists for the insights that they've brought, and another thank you to Professor Wojcik for his leadership. All right, I'll turn it back to you, Professor Wojcik. I know you want to conduct an election.
Thank you, Layla. I think you have the list to share with us on the screen. I get to share with you the nomination committee report. The chair is Hari Osofsky. Chair-elect Leila Sadat. Secretary Jason Palmer from Stetson. Treasurer Sahar Aziz from Rutgers Law School. Members of the executive committee are Lisa Benjamin from Lewis and Clark, Victoria Sahani from Arizona State University, Janie Chung from American University, George Edwards from Indiana McKinney, Cindy Bias from Southern Illinois University, Craig Martin from Washburn, Tom McDonald from Pace, Melena Stereo from Cleveland Marshall, and me, who also gets to become immediate past chair. That's our slate, and I move that we adopt it. Assuming that the ayes have it, we have our new executive committee and section officers. Thank you all for joining our session today, and thank you for participating in this program.